Here's a summary of the June 5th, 2025 Supreme Court opinion in the case called C/Devas/Mauritius Ltd versus Antrix Corp, case number 23-1201. It's a pretty dense question about personal jurisdiction. Please note that this summary is read by an automated voice. The questions presented in this case are whether plaintiffs must prove minimum contacts before federal courts may assert personal jurisdiction over foreign states sued under the Foreign Sovereign Immunities Act. The question presented in Antrix Corporation Ltd is, under the Foreign Sovereign Immunities Act, personal jurisdiction over a foreign state shall exist as to every claim for relief over which the district courts have jurisdiction under subsection A, where service has been made under Section 1608 of this title. 28 United States Code, Section 1330B.
Justice Alito delivered the opinion for a unanimous court. Justice Alito's unanimous opinion.
Devas Multimedia Private Ltd signed a satellite leasing agreement with Antrix Corporation Ltd, which is owned by the Republic of India for use by its Department of Space. But when the Indian government later determined it needed more satellite capacity for itself, Antrix terminated the contract under its force majeure clause. The parties proceeded to arbitration. After unanimously concluding that Antrix had breached the contract, the arbitral panel awarded Devas $562.5 million in damages plus interest. Devas then petitioned the United States District Court for the Western District of Washington to confirm the award.
The district court confirmed the award and entered a $1.29 billion judgment against Antrix. The Ninth Circuit reversed, finding that personal jurisdiction was lacking. Under the Foreign Sovereign Immunities Act of 1976, FSIA, personal jurisdiction over a foreign state shall exist whenever 1, an immunity exception applies, and 2, the foreign defendant has been properly served. The Ninth Circuit did not question that Antrix is a foreign state under the FSIA, that an immunity exception applies, and that Devas effectuated proper service. Yet bound by circuit precedent, the panel explained that the Act imposes an additional requirement. Personal jurisdiction under the FSIA also requires a traditional minimum contacts analysis, as set forth in International Schuko v. Washington, 326 U.S. 310. And its progeny. Applying that standard, the court concluded it could not exercise personal jurisdiction over Antrix because Antrix lacked sufficient suit-related contacts with the United States. Held, personal jurisdiction exists under the FSIA when an immunity exception applies and service is proper. The FSIA does not require proof of minimum contacts over and above the contacts already required by the Act's enumerated exceptions to foreign sovereign immunity. A. The FSIA's personal jurisdiction provision imposes 2 substantive requirements. First, the district court must have subject matter jurisdiction, which the FSIA grants whenever an enumerated immunity exceptions applies. Second, service must be made under the FSIA's specialized service of process rules. When both criteria are satisfied, the statute declares that personal jurisdiction shall exist. Accordingly, the most natural reading of the operative text is that personal jurisdiction over a foreign sovereign is automatic whenever an immunity exception applies and service of process has been accomplished. Notably absent from the provision is any reference to minimum contacts, and the court declines to add what Congress left out, as the FSIA was supposed to clarify the governing standards, not hide the ball. Of course, the FSIA's immunity exceptions themselves require varying degrees of suit-related domestic contact before a case may proceed. But to the extent these exceptions satisfy international SHU, it is because the exceptions Congress wrote happen to meet that standard, not because the Act's personal jurisdiction provision secretly incorporated the court's due process cases. The Act's structure reinforces this reading. The FSIA comprehensively regulates the amenability of foreign nations to suit in the United States. The immunity and jurisdictional provisions form the foundation of that comprehensive scheme, and Congress deliberately tied them together. Whenever an exception applies, the FSIA strips immunity and grants jurisdiction. Reading an additional minimum contacts requirement into only one of the FSIA's tethered immunity and jurisdictional provisions would weaken the link Congress forged and create a gap in the Act's otherwise comprehensive framework. B. The Ninth Circuit's two contrary arguments cannot override the plain meaning of the FSIA's personal jurisdiction provision. First, the fact that one of the immunity exceptions contains language resembling the minimum contacts test says little about whether a jurisdictional provision located elsewhere categorically imposes that test. Second, the legislative history cited by the Ninth Circuit shows only that Congress believed the contacts set forth in the Act's then existing immunity exceptions satisfy due process, not that the personal jurisdiction provision silently includes an atextual minimum contacts requirement. C. Antrix's alternative arguments that the Fifth Amendment itself requires a showing of minimum contacts, that the claims at issue do not fall within the FSIA's arbitration exception, and that the suit should be dismissed under forum non-convenience, were not addressed below by the Ninth Circuit. This court declines to address them in the first instance, reversed and remanded.
Case implications. The Supreme Court's unanimous decision in CC/Devas versus Antrix clarifies that personal jurisdiction under the Foreign Sovereign Immunities Act, FSIA, requires only that an immunity exception applies and proper service is made without any additional minimum contacts requirement. This straightforward interpretation removes a significant jurisdictional hurdle for plaintiffs seeking to enforce arbitration awards against foreign sovereigns in U.S. courts, potentially increasing the enforceability of such awards. Lower courts must now focus their jurisdictional analysis solely on whether one of the FSIA's enumerated exceptions applies and whether service requirements have been met, without importing constitutional due process standards designed for private entities. The decision preserves the comprehensive framework Congress established in the FSIA by maintaining the intended relationship between immunity and jurisdiction. While the court declined to address whether foreign states are persons entitled to Fifth Amendment due process protections, this unresolved question may generate additional litigation as foreign states continue to challenge personal jurisdiction on constitutional grounds. The decision also leaves open other potential defenses for foreign sovereigns, including forum non-convenience and arguments about the scope of the FSIA's arbitration exception, which may become the new battlegrounds in international arbitration enforcement actions.